The President of the Legislative Council. Good morning, members. The Council continues to deal with Mr. Albert Chan. Allow me to finish my sentence, please. The Council will continue to deal with what Ms. Ho has proposed in accordance with Rule 41 in relation to the adjournment of the debate. First of all, I would like to invite Mrs. Ho to give a reply. Mrs. Ho will give a reply, and after that, the debate will come to an end, and the motion will be put to the vote. Mr. Albert Chan, Mr. President, before we ended last night, there were 35 pro-establishment camp members there here. Now, I would like to have a quorum count. Albert Chan. Mr. Ho, you may now reply. Thank you, Mr. President. Good morning, members. For the past 2 days, that is both yesterday and the week before this week, I have listened very carefully to what the Secretary has said and what members have said. I've made notes. In fact, I have sufficient information to mock, to rebut what members have said, but I don't want to do that. I am moving a motion to adjourn the debate. I don't want to pick a quarrel. I just want to resolve the problem. I would like to find a way to provide a buffer so that we can get away from this controversy. So first of all, I'd like to invite the pro-establishment camp to set aside our political differences, and please do not simplify our motion as part of the filibustering effort. If you haven't listened carefully to our arguments and you simply impute a motive to us and try to speak accordingly, then I'm afraid we can never find a good way to resolve the present problem, and there will be no exit from this debate. So I really hope that you will take it back to the core of the issue. Well, it's better to be patient, and then we can have a good result. Last time I said that we should pause and think. Now, when we pause, in what direction should we think and what factors should be considered so that the copyright owners as well as the general public will have their freedom of speech, freedom of information, and freedom of communication will be balanced so that there will be a consensus, so that the copyright ordinance of Hong Kong will be on a par with the international trends, so that there will be a win-win situation. Here, I must put it on record. That is, we are most grateful to Professor Yu. Well, Professor Yu, Professor Peter Yu is a locally born scholar, and currently he is the current family chair in intellectual property law, Drake University Law School in the United States. And in fact, he is also the editor of an international journal of intellectual property. I'm sure in this way we can see that Professor Peter Yu is on a par with the authorities that the Secretary has cited. He teaches intellectual property law. He also attends many conferences in relation to discussion of intellectual property law. So he is most familiar with the US and the UK laws in this field. And during the Christmas season, he came to Hong Kong for the purpose of visiting families, and he has kindly offered a lot of views and has attended many talks. And I have tried to see if the Secretary can understand what Professor Yu has been saying, so as to reduce the differences between the industry as well as what we have been talking about. Professor Yu has attended our so-called tutorial classes, and he has given a lot of insights. The most enlightening point is that he said that as far as the government is concerned, the government doesn't have to have a policy. The role of the government when it comes to copyright is to balance different interests. So it could be an organization which has bought a copyright, say, for example, the Copyright Alliance, the general public, authors, writers, or the platform or the middleman. So the government's role is to find something which can satisfy everybody, which is fair, and then the industry can develop on its own. There's no need for the government to do anything to promote the industry. Unfortunately, so far we haven't been able to do so. The crux of the matter is that copyright owners, which are commercial organizations, and the netizens are having disagreements. If we want to find a way to resolve the problem, It means that both parties should be willing to sit down and have a discussion and try to identify the common points, and then we can try to find out about the differences in opinions, and then we try to reduce the gap, and we try to ease the worries on the other party, on the part of the other party. Well, in fact, between copyright owners and the netizens, there are three common points. First of all, we agree that piracy should be eliminated. Piracy and infringement are different. Currently, what netizens are doing will be regarded as infringement on an individual basis. This is not the same as piracy. For piracy, it means that you get others' creation and then you try to use it for your own purpose, for commercial interest. Nobody would be fighting against the efforts to eliminate piracy. Even for me, who's against criminalizing the infringement acts, we are against piracy. In the year 2009, there was an amendment concerning copyright in relation to printed materials. I read the Hansard. The Pan-Democrats didn't even speak, and we just voted in favor of the motion. This is because on that occasion, the threshold was pitched at a very reasonable level, and the threshold was clear when it came to the elimination of piracy. In other words, when in our daily lives, in educational services, in other social services, we would not become an infringer. There were two elements. First of all, within 14 days, you are not supposed to make photocopies of more than 500 pages. 500 multiplied by 14, in other words, divided by 14, it means 40 pages per day. So normally speaking, you won't be making that many photocopies. The other threshold was that within a period of 180 days, the value of your photocopies should not exceed $6,000. In other words, you don't come across such a scenario in your daily lives. So by having such a clear threshold and by having clear criminal provisions, we would not object to it. So that's the first point. However, the current debate is such that, and we've seen it for ourselves, there is the infringing acts have been expanded to the digital devices and the use of such devices for the purpose of communication. In other words, people in all age groups would do this in our everyday life. In other words, we can easily find ourselves being the targets of criminal offenses. And then even for the Copyright Alliance, they have said that they have time and again made public promises saying that they are not going to assist the government in providing evidence. Well, by not providing the evidence, the government would not be able to launch any criminal prosecution. We do welcome such a promise, such a pledge, but what worries us is that once something is written into the law, yes, the alliance may very well say that they are not going to help the government by providing evidence, say what Mr. Lam has said. Yes, this is a pledge on their part, but once something is written into the law, there is the possibility of prosecution. The government can prosecute, and other commercial organizations which are politically motivated may also prosecute the offenders disregarding the amount of money involved. Now, we would like to talk to the alliance so that we can make sure that they won't be suppressing freedom of speech. In fact, they've told us frankly that they were most concerned about streaming, infringement by streaming. So they've been quite specific about their concerns. However, this is not played out in the law, in the bill. Rather, it is very broadly worded, and they've been given a very specific right of communication in the digital world, and then the government tries to provide some exceptions. So the offense is broadly worded, and then there are narrowly defined exceptions, so the government will have huge powers. And the third common point is that we would like to promote and develop our creative industries. However, for the commercial organizations which are owners of copyrights as well as the creative industries, I'm afraid the way that fees are charged has told us that it is an outdated model. Well, I think something is still not being said by the alliance. Well, I think they are really worried that they cannot impose a charge or collective fee from the intermediary platform. So they would rather make infringement criminal, because once you've exempted them, the fees will not be of interest to the intermediary platform. By criminalizing the infringement acts on an individual basis, then the intermediary platforms will be motivated to talk about the fees. I'm referring to organizations like YouTube as well as Netflix, which carries a lot of Hollywood films. Well, $63 is the monthly charge that you pay, so it is quite similar to what you pay for one movie when you go to the cinema. If we haven't got a provision to prevent anybody from watching a movie streamed, then of course nobody would be interested in paying up dozens of dollars for the enjoyment of the films. Well, the netizens have also agreed that we need to develop our creative industry. Well, a lot of people have talked about the live streaming of video game playing. Well, in fact, it is a very active economic activity. We are grateful to the netizens for telling us what this is like. Mr. Law has also been making some income, getting some pocket money by commenting on the live streaming of the video game playing. We understand that somebody could make $4 million by acting such a commenter. And in Taiwan, there's this commenting platform was bought by Amazon for $900 million. So you see that there is a huge business opportunity. It is something very new, and I hope that the Secretary will read what Charles Mock has written in the Hong Kong Economic Journal last week. Whenever there is a new economic trend, then industries have to change accordingly. Now, for the music record industry, it is said that once you have another innovation, another invention, then people may no longer be going back, adhering to the old model. Usually they are worried about the new models. However, when you take the industry as a whole, when you look at the revenue of the industry as a whole, well, in fact, the revenue is increasing all the time. The question is, operators used to the old model, they need to change so that they change their business model, and then they can maintain the level of income or revenue. Well, Mr. President, we had tried to ask the Secretary as well as members from different parties to get the different parties and different interests to attend a meeting so that we can develop something which is acceptable to all. I'm afraid the bill in its current form has given a lot of room to the government to prosecute. Yes, the government is trying to say that it won't do so, but then the provisions do allow the government to do so, especially when we see that the government can invoke the public places of entertainment to prosecute the alliance. and they can ask the different levels of the courts in the judiciary to go after Mr. Stephen Chen, then we are afraid that we can't have trust in the government. We hope that the provisions will be clearer so that the citizens will have better protection. So I really call upon the administration to listen to us, and I hope members will agree to this motion so that all parties involved can develop something which is acceptable to all. I now put a question to you, and that is that the motion moved by Honourable Sid Ho under Rule 41 of the Rules of Procedure that the debate be now adjourned be passed. I would like to ask for a division. Ms. Sid Ho asked for a division. The bell will be rung for 5 minutes.
開始表決。
Voting begins. Members, order please. Voting begins. Members, please check your vote. If there are no questions, voting comes to an end. The voting results are to be displayed. Members returned by FCs 30 present, 8 for, 22 against, no abstention. Members returned by GCs 33 present, 19 for, 13 against, no abstention. The question hasn't been agreed by a majority of each of the two groups of members who are present. I declare the motion negatived.
This Council will now continue the second reading debate on the Copyright Amendment Bill 2014. Does any member